There is a verdict in the civil trial against Donald Trump. It was filed by writer E. Jean Carroll. She accused the former president of raping her in a department store dressing room back in the 90s. I've got the verdict sheet just in front of me right now. I'll walk you through. There were ultimately 10 questions resting on the question of whether she had been raped by Mr. Trump, also questions of whether he had defamed her on the battery charge. And that gets to, again, the accusation of rape. Question one, did Mr. Trump rape Miss Carroll? The jury voted no. On the question of did Mr. Trump sexually abuse Miss Carroll? Yes, the jury said. Moving down to question four, Miss Carroll was injured as a result of Mr. Trump's conduct. The jury said yes. And if yes, inserting an amount of $2 million, a monetary judgment against the former president. Keep in mind, E. Jean Carroll's attorneys did not ask for a specific amount of money. They left it to the jury. Moving on to the question, Mr. Trump's conduct was willfully or wantonly negligent, reckless, or done with a conscious disregard of the rights. Yes, the jury said. Now, moving down to the defamation question, there were ultimately 5 questions related to that accusation. Did Ms. Carroll prove by preponderance of the evidence that Mr. Trump's statement was defamatory? The jury said yes, it was. Did Ms. Carroll prove by clear and convincing evidence that Mr. Trump's statement was false? The jury said yes. Mr. Trump made the statements with actual malice. The jury, yes. And then we're still waiting on some of these other questions. But again, the big headline there, the jury finding that Mr. Trump did sexually abuse Ms. Carroll. Let's go to Laura Jarrett right now. Our legal analyst is standing by. Laura, what do you make of, first of all, that this jury came back in under 4 hours, I think nearly 3 hours, and what we've heard right now in terms of a verdict? Yeah, so fast. Clearly a resounding victory for E. Jean Carroll, who had accused the former president of sexually assaulting her in that dressing room some 20 years ago. The amount here, Lester, is staggering in some ways, given that the jury was not offered a specific amount to award her. All of these numbers that you were just reading out for our audience are numbers that the jury, these 9 jurors, have come up with themselves. They had made a specific strategic move not to ask for a specific dollar amount, and the jury has come up with these numbers in the millions now, including punitive damages, which really speaks to how these jurors viewed the evidence. And just to remind everybody, this was a 9-day trial, relatively short given the stakes against the former president. He has denied all of the allegations vehemently. He said he didn't even know who she was, much less attack her. But she testified over the course of 2 days. The jurors also heard from 2 other women who had accused the former president, claims he also denied. But it was used as evidence to show his playbook when it comes to women. The jury also heard from 2 friends who Carroll said that she told at the time, contemporaneously, about the assault. That perhaps may have bolstered these claims, even though they were so long ago. Perhaps the jury found her more credible, given the 2 other women that testified. And then, of course, Lester, the former president never showed up in person. He was tweeting about his travels overseas to Scotland, but he never showed up. And that is something that was hammered in closing arguments by Carroll's attorney yesterday, Lester. Laura, help me with this question. On the first question, Mr. Trump raped Ms. Carroll. The jury said no, but they came back and said yes on whether he sexually abused Ms. Carroll. From a legal standpoint, where's the daylight? The issue is really one of force. The law obviously breaks down the claim of battery, which was her core claim about what she says happened in that dressing room. And the judge walked them through the legal standards and it basically allowed them some wiggle room. If they didn't find forcible rape, they could use 2 alternatives, one being forcible touching or being sexual abuse. And sexual abuse is what they found that he actually did do, which includes everything from a pinch to rubbing, touching, anything like that can constitute sexual abuse in this conduct. And that's what the judge instructed the jury here today, Lester.
Thanks for watching our YouTube channel. Follow today's top stories and breaking news by downloading the NBC News app.